Welcome to Discovering Justice. My name is Lucy Rivera, and I am your host today. In our program today, we have a really special guest, Attorney Julian Tynes, who is the chairman of the Massachusetts Commission Against Discrimination. Welcome to our program, Attorney Chairman Tynes.
Thank you.
It's good to have you, and congratulations on being the new chairman of the Massachusetts Commission Against Discrimination.
Well, thank you. I appreciate that.
What do you see the agency, the MCAD, what are their priorities? Where would you like?
Well, we have a few priorities. Obviously, our statutory mandate always is to address and eradicate discrimination in the Commonwealth of Massachusetts. The other priority we have, obviously, is to prevent discrimination. And there's a variety of ways we want to attack that or address that. But one of the things that's on everyone's mind when we come, everywhere I go, people ask about the backlog, about the number of cases at the MCAD. So one of our goals, and one of the things that I want to do, is we want to address the backlog, as well as we want to expand the outreach of the MCAD, because we really believe that education and outreach is the best way to prevent discrimination.
That's correct. And would you like to expand as far as the education component of the MCAD?
There's a few things we want to do. First of all, the MCAD has 4 offices. And one of the things that's happened, we have a large concentration of people in the Boston office. The next largest office is in Springfield. But in the Worcester and in the New Bedford offices, they're basically at this time one-person offices. So one of the things, part of our goal is to reallocate resources to expand the number of people we have working there so that we have more people available to go and take discrimination claims. The other thing we would like to do is we want to expand our education and outreach. We're reaching out to immigrant groups, to community groups, to speak to them so that people will know their rights and will come to us, because one of the things that we've realized is, especially first-generation Americans that may be subject to, for example, national origin discrimination, they are less likely to come to a government agency to make those complaints. And what we found by talking to those groups is that they hear discrimination claims that we never hear. So by working with them, we'll be able to address those claims. The other thing in education and outreach we want to do is we want to reach out to small businesses. Because one thing we found, a lot of the claims that we get, come from small businesses. Large corporations tend to have HR departments, they tend to have legal teams, so they know compliance with the law. The small business owner is less likely to do that. He is not going to hire an HR department, human resources department, strictly for that purpose. And so we believe by reaching out to chambers of commerce, to the small businesses, we can show people that to set up a discrimination-free workplace, to set up a discrimination-free place of public accommodation is not expensive, and that compliance can actually be less expensive than non-compliance.
That's great to hear, Chairman. And now, as the chairman of the MCAD, how do you see your role versus those of the commissioners?
Well, as all commissioners, we all have duties in regards to cases. We all have duties in regards to reviewing the law. The chairman, however, has a different role in the sense that the chairman is being head of the agency, for example, for the contracts. The chairman is the head of the agency for purposes of contracts. In personnel procedures, the chairman is the titular head of the agency. And so in that sense, it's a little more responsibility. It's a different type of responsibility. We all share certain roles, but the chairman has the roles. For example, all the federal contracts, the state contracts, I'm responsible for those and for signing those. So
that's a big role, chairman of the MCAD.
Yes, it's a great honor.
It's a great honor.
It's a great honor, great responsibility and a great honor.
And great work.
And great work. It's a great agency. We have people who are truly committed, who work there, who are truly committed to the mission of the MCAD. And that's one of the things that makes it great working there.
And talk to us about your background a little bit.
All right. I grew up in the western part of the state, and after college, I worked for Big Brother in Boston, And then I was a school teacher in the Boston Public Schools for a time. I decided to go to law school. I moved to Springfield, and I went to law school at night while I taught during the day. And after that, what I did eventually, I started working for a labor union in Connecticut. And I represented municipal employees and police officers. And after a time, I was able to get a job working with the Commonwealth of Massachusetts within the Executive Office of Health and Human Services. And I worked for what was then the Department of Mental Retardation. Now it's called the Department of Developmental Services. And I was their Labor and Employment Counsel. And I worked with them from July 2001 until September 2010 when I came to the MCAD.
And as an advocate at the Labor and Employment with the Department of DMR, now that you've made the transition as a chairman, it's more of a neutral position. How do you balance that?
Well, I think that really it gave, by working both sides, because before I basically represented complainants, I represented union members, then I represented employers, managers. So, but the good thing about representing employers and managers is not only did I represent them, but I also advised. So one of my duties was to advise the department on setting up a discrimination-free workplace. For example, setting up discrimination-free personnel policies and procedures, policies for personnel policies, policies for FMLA, reviewing those things. And so because of that, it gives me, as a neutral, in this capacity, I see both sides of the issue when the issues come before the MCAD. So it gives me a perspective that, in a way, it's the type of thing where you don't realize it at the time, but it was good training for this position.
Yes, that's a very interesting background and what you bring to the chairmanship. And as a chairman, what do you say would like to see at the MCAD? What do you like to see different?
Well, the first thing is I would want us to have an expanded outreach, like I said, where we're actually reaching out to communities. Because what we're trying to get away from is we're trying to get away from the image of the MCAD as either a city-based organization or a downtown-based organization. And the other thing, one of the things is we want to go and represent all of the citizens of the Commonwealth. If you look at our statute, that's what it says, the citizens of the Commonwealth. And we take our cue from the governor. The governor, when he ran and as he's governed, he's been across the Commonwealth. He represents all the citizens of the Commonwealth. We look at that as part of our statutory duty. So that's one thing we want to do. Like I said, I want to increase education and outreach to a large degree. And we also want to put in more efficient procedures so that we can go through our cases quickly, more often, so that we can get people justice faster. And one of the things, we want to reach out to businesses because we don't want business to look at the MCAD as the gotcha place, as we're out to only get people, that we're there to give people a hard time. No, we also want to offer training to be their partner in the sense that we can show them how to set up, like I said, discrimination-free workplaces, that we can show landlords, because we also have some jurisdiction over housing, how they can set up discrimination-free housing. So that, we want to go do those type of things, to go build that type of relationship, so that, because the purpose is to help the Commonwealth have basically as discrimination-free a state as possible.
Yes, that is a lofty and worthwhile goal.
It's a lofty goal, yes.
And in that vein of representation of the constituency, how would the MCAD facilitate or encourage complainants, those who bring the complaint against to the MCAD, to retain private counsel versus going on pro se?
Well, when we do appoint counsel, when we appoint counsel is when it's reached the probable cause stage generally. And what will happen is that what we will do is if the parties, they can go to mediation. If it doesn't work, if they're going to go forward, we have attorneys that are commissioned counsel, and the person will go, they keep the case at the MCAD, and the commissioned counsel will represent them. Now, when I say represent them, what has to be understood by our statute, the MCAD always represents the public interest. And so, for example, there may be a case at times where the private interest, and the reason I'm saying that the private interest may differ in that, for example, a complainant may want something that may not achieve the public interest. For example, a person who's been suspended from work for 2 weeks and they want $500,000. Well, we're not going to argue for that because that, one, it doesn't achieve the public interest. Two, if they've been suspended for 2 weeks, it's highly unlikely they're going to get a $500,000 judgment. I mean, but that's one way that we try to do that. The other thing is through our mediation programs and through other programs we're trying to look at other ways in which these discrimination issues can be resolved, in which people can also be appointed counsel to help them through this process. Because what we're believing is that if we can do it in that way, we can, one, we can have people who are represented, and two, we can achieve results faster, and especially if we can get it either through some type of mediation or other programs we're looking at. What we want is for both parties to walk away from the table. Now, there's obviously going to be cases where that's not possible. There's going to be cases where there's discrimination that may be rampant. There may be something that's terrible, heinous. And our job is to enforce the law, and we're going to do that. But there's other cases where perhaps we can work something out, where we can address the public interest, we can address the private interest, and we can end the discriminatory practice without having to go through the whole hearing process. If we can do that, we're going to try to do that too.
So you would investigate not only complaints that come to the MCAD, but would you also investigate those cases that don't necessarily file complaints with the, I'm sorry, not against, but with the MCAD?
Well, yeah, in the sense that, for example, we have something called the commission-initiated complaint. And what can happen is we can hear of discriminatory practices. A person may not come in and file a complaint, but because we hear about this, a commissioner may go initiate an investigation, what's called a special investigation. And by looking at that special investigation, depending upon the information that's gathered, the MCAD may then go forward with what we call a commission-initiated complaint. Then there is no private party that is listed as a complainant. The MCAD is the sole complainant. And cases like that are done for the public interest. And for example, one of the ways that's done, a form of that is our testing program. Because our testing program is something where we may get complaints. For example, someone may say they don't hire this type of people. They discriminate against these type of people. They discriminate against women. They discriminate against this. And so what we will do is we will get a group of people we call testers. They'll all be qualified, but they'll be a diverse group. They will be diverse in age. They will be diverse in gender. They will be diverse in ethnicity. We'll send them in, and we'll see what happens during the hiring process. And for example, there was a case that happened. Well, when I first came in September, it was being settled, and it involved a place that sold ice cream. And the allegation at the time was they were only hiring young ladies between 17 and 24 years old.
All sorts of discrimination is going on there.
Yes, and so it was an age discrimination claim. We didn't even go to the gender. We didn't even go there, but it was an age discrimination claim. And so that was the case, and it was brought about by testing. We sent in, the testing confirmed it, and then we went forward from there. So that's one of the things we do. And yes, we do have that authority, and we also have some, for example, in housing in that way, for not only testing, but for example, we have one where there was a discriminatory ad, an advertisement. And from the discriminatory advertisement, we did a special investigation on that. And this case actually involved something called a restrictive covenant, which is illegal, and which is supposed to be void by public policy. And this restricted covenant said that the land could not be sold to certain groups. It could not be sold to people of certain color. It couldn't be sold to people who may who have a certain ethnic background. Well, that's void by public policy. It's against the law. So once we saw that in the advertisement, that became a commission-initiated complaint. So we can do that.
But that covenant was there, did you say it had been there since?
Since the early 1900s, at a time when it was not void.
And now as a matter of public policy, even though their argument was that...
The argument that they were trying to make is that the covenant runs with the land.
Right.
In other words, as each party bought it, when they bought it with that understanding, and it runs with the land and it continues to perpetuity. Well, the problem with that is that now that is illegal. And so anything that is illegal would be void by public policy. And the problem was that, one, they were doing this and they were trying to go by this, and the other problem, by this void, which should be a void covenant.
Right.
So they were only allowing certain people to even be eligible to buy this property. The other problem was the newspaper that was advertising it, it's against the law for them to even do that.
That's correct.
And so
that's how you found out about it.
That's how we found out about it. And so that's why we're still following up on it. And that's actually something we're working with a few other groups, the Attorney General's Office, HUD. So there's a few other groups we're working with on this to try to go get the right result.
And in that vein, what are the agencies, the other agencies that the MCAD collaborates with to investigate or bring these cases down?
Well, it depends on the case, but we work with a few agencies. One agency we work with a lot is the Attorney General's Office, the Civil Rights Division. We worked with them, for example, there was a public accommodations case a few months ago involving students from Harvard and allegations of closing a club early, and we worked with them on that. We work with the EEOC, we work with HUD. We work with the Fair Labor Division of the Attorney General's Office.
Some federal agencies?
Yeah, HUD and the EEOC are federal agencies. We'll work with the State Department of Labor, and there's some collaborations where there may be times we end up working with the Federal Department of Labor. So there's a few agencies we'll be working with.
Oh, that's great.
And we work with, so yes.
Thank you, Chairman Tynes. And again, you are here in one more program of Discovering Justice. My name is Lucy Rivera, and I am your host. And our guest today is Chairman Julian Tynes, the chairman of the Massachusetts Commission Against Discrimination, also known as MCAD. And Chairman Tynes, I wanted to ask you about your budget. What are the challenges you're facing in today's state and federal budget constraints?
Well, there's two things. First of all, unless someone's been like Rip Van Winkle for the last 3 years, everyone knows the economic situation of the country, the world as a whole. And so obviously the state budget's affected. Now, the governor, obviously, when that happens and they have to cut back on state funding, one of the things that are looked upon is all agencies. Now, under this administration, we've been treated very well. The Patrick administration has, they've had a strong commitment to civil rights and to equal rights for all. And that commitment is shown not only in their language, but in their acts. And one of the things is the budget. But obviously, this was also a time when basically all state budgets would have to be cut. So all state agencies' budgets have to take a cut. Ours was very, very small, but as I said, all do. And since most of our budget goes to salaries, if it gets cut too much, then we're looking at cutting positions. Now, what's really may impact us is the impending federal government shutdown, because out of our total budget, 60% comes from a state appropriation, 40% comes from our federal contracts with the EEOC and with HUD. Now, the EEOC is the Equal Employment Opportunity Commission, and HUD, Housing Urban Development. Yes. But so what happens, though, if we lose that 40% for a significant time period because of the federal government shutdown, that would severely impact our budget. And the problem is, if it severely impacts it where we have to lay people off, well, once you're laying people off, there's less people to do investigations. There's less people to, we have hearing officers. And I'm not saying we would lose hearing officers. We'd probably lose investigators. We might lose support staff. But that means that the backlog that everybody complains about, that everybody worries about, would grow.
That's right.
Because what happens is, even though there may be a reduction in staff, there is no reduction in the number of claims that are coming in. And one thing we found is, especially in severe economic times, there seems to be a tendency for there to be more claims. And so that would have a big impact on us.
That's correct. And speaking of trends, would you care to comment on what do you see are the national and state trends in terms of bringing complaints, discrimination complaints?
All right. Well, the areas that I see are growing, one area that's growing is disability claims. And one of the things is, one, there's a growing awareness. With the amendments to the ADA, the recent amendments, which expanded the definition of a disabling condition, that means more people are now eligible for accommodations under the ADA. And as those accommodations aren't granted, that would lead to more discrimination claims. So that's one area that's growing. And one area that's really growing is religious discrimination. And that comes from, we've had some failure to accommodate for different religious beliefs from the mainstream religious beliefs of most citizens of the United States, where people may not, for example, be allowed their Sabbath off, to blatant discrimination, including nationally, there's been allegations of anti-Muslim discrimination. And examples were given, for example, some people believed it was discriminatory when nationally there was a hearing supposed to be on terrorism, and it basically became a large hearing on Muslims and terrorists. And then that was a national stage, and recently in New York State, there was an assemblyman who also brought a group together, and what they talked about was Muslims and terrorists. And these are state things happening on a government level that people are concerned about as far as discrimination, but discrimination claims are rising. And that can be concerning, especially because especially with religious discrimination, because that's one of the areas that traditionally, in the United States, the idea is that we're supposed to respect each other's religious beliefs. And so that's a problem.
Right. You also mentioned the Americans with Disabilities Act Expansion.
Yes.
I'd like to ask you to comment a little bit more as to what are those new, I guess, amendments to the ADA?
Well, one of the things is the definition, like I said, of a disabling condition has been expanded. At one time, it had to be permanent, chronic. Now, it's expanded. It does not have to be permanent. It can be a condition that lasts more than 6 weeks. It can be episodic in nature. It can be chronic in nature. And so, or it can be, for example, it can be something that would be a disabling condition that's in remission. For example, someone who has cancer is now in remission, but they would still be considered disabled. And so one of the things that makes it difficult also is the idea of what a disabling condition is can be individual in nature. Because for different disabling conditions, they manifest themselves among different people in a different manner. I'll give you the example of arthritis. Arthritis, for some people, my knee's bothering me a little, they're fine with it. For some people, they literally cannot move, they literally cannot function. So for them, it would be a disabling condition.
I see. So it's in the meaning. Chairman Tynes, we're running out of time, but there's a lot more to talk about in terms of the amendments to the ADA and amendments to our chapters here for discrimination law. But I'd like to thank you for being our guest today and for giving us the time to be here.
Well, thank you. Thank you for this opportunity. Thank you very much.
And to all of you, thank you for following this program. And my name again is Lucy Rivera. Today we had Chairman Julian Tynes, who is a commissioner of the Massachusetts Commission Against Discrimination. And I'd love to hear your thoughts about future programs and about this program. So please contact me at lucinda.rivera@gmail.com or at www.discoveringjustice.net. This program and all our previous programs will be also at www.discoveringjustice.net. And thank you for coming, and we hope to see you next time.